Great. Welcome, everyone, to the third talk of the Institute seminar series on democracy and governance in the Americas. I'm very pleased to be welcoming my colleague and friend, Dr. Ursula Hackett of Royal Holloway, who's giving a paper entitled Policy Delinking, How Policymakers Protect Controversial Policies in Court. So please go ahead.
Thanks so much, Nadia. And thank you, Nestor, also for the invitation to speak. I'm absolutely delighted to talk to you today. I'm going to share my screen now. I see that I'm not able to share my screen. I think perhaps I need some permissions there in order to.
Maybe you need to be a co-presenter or something.
I think that might be it.
Let's see if we can.
There we go. Yep.
Nice.
We're fine. Done. Okay, so I hope you can see my screen now. I'm going to start my presentation here. There we go. So, well, thanks so much for the invitation. And I'm absolutely delighted to be able to talk to you about my research on the strategic interactions between American state legislators and the courts. And I'm going to draw in this presentation primarily upon my recent paper that I've written on the politics of abortion and gun control, but I'm also going to draw, I think, from some of the work I published in my book, America's Voucher Politics, How Elites Learn to Hide the State, the paperback version of which is out in January the 6th, in which I describe the situation that led to the expansion, the rapid expansion, particularly over the last decade or so, in the number of school voucher programs across the US. And these programs that offer a sum of public money to spend, the parents to spend on private education for their children. And the puzzle that animates the book is, how did this happen? How did these programs pass and then survive, given that they face such formidable legal obstacles, constitutional obstacles? And the answer that I identify in this book is that policymakers, conservative policymakers, learned tactically, patiently, iteratively over the course of a long, many decades about the sorts of policy designs and the sorts of rhetorical strategies that would allow them to defend those policies most successfully in court and to insulate them from legal challenge. So I'm going to draw on those on that work, but I want to start by with Texas's SB 8 heartbeat law, and I'm sure many of you, of course, will have been following the course of this particular piece of legislation. Of course, this is a piece of legislation that bans abortion after 6 weeks of gestation, approximately, when the fetal heartbeat can be detected, and in a shocking move on September the 1st this year, the federal Supreme Court refused to block enforcement of that law in a way that it had done for other equivalent pieces of legislation. And the reason that it was able to do that was because Texas took a very creative, strategic approach to that law, which is that they outsourced enforcement of that law to private citizens. Such that, so instead of having government officials actually enforcing the law, they had private citizens are encouraged to sue abortion providers or those that help people to procure abortions, and to there's a fund that's available for people who are doing that, and so they can claim in court that no government official is involved in the execution and the enforcement of that law. And that's what enabled a bare majority of the Supreme Court to find that that law can go into effect. Of course, it went into effect immediately. In dissent, Chief Justice John Roberts argued, and I quote, "The desired consequence appears to be to insulate the state from responsibility, and that the courts should consider whether a state can avoid responsibility for its laws in such a manner." And I think that this case is one of a much broader class of instances in which policymakers have acted in a very creative and strategic way to hide the role of the state in producing particular controversial policy outputs. Now, they can do this in a variety of different ways. And I talk about in my voucher work about the ways in which policymakers have used the tax system to deliver particular benefits, to privatize, to delegate the provision of a particular benefit in order to attenuate the connection between, on the one hand, the state governmental action on the one hand, and then some sort of controversial policy output on the other, whether that's a benefit to, in early instances, a segregated schooling, and later religious schools. Of course, there's establishment clause, legal questions that arise there. So there, but this is all part of a broader story here about ways in which the state's role has been obscured by means of these indirect approaches to governance, whether that is through segregationists, privatizing the white primary when the white primary was outlawed, unconstitutional, that's saying that these are private entities, this is not state action, privatizing swimming pools, recreation facilities, and so on, and transferring it to public-private hands in order to avoid the imprimatur of the state. But lest you think that this is only a conservative maneuver, I would say that there have been instances in which liberals have sought out these attenuated, indirect, subtler ways of achieving their aims, whether that's during the 1980s when you have the backlash against affirmative action and you get the sort of and race-conscious approaches to public policy making more generally, and you have policymakers seeking out Section 8 housing voucher schemes and supporting those rather than the sort of direct subsidy of the public housing, but to subsidize the individual to use their private choice to direct the benefit to in the private marketplace. And even more recently, if you see in the litigation that followed the passage of the Affordable Care Act and the particular controversy that arose over the contraceptive mandate, which religious organizations saying, look, this is a violation of our religious beliefs. And so the Obama administration is forced to argue in court that we're not going to simply require you to provide the contraceptive coverage, but we're going to allow you to simply signal your opposition, and that's going to trigger a process by which some third-party organization is going to provide the coverage to employees. And so there are all the sorts of situations in which it is expedient, I would argue, for legislators to hide the role of the state in these different ways. And what I'm going to elucidate in this particular paper is that you can engage in these privatization maneuvers, these delegation maneuvers. You can also try to disavow controversial intentions and deny controversial effects. And what I'm calling this is this idea of delinking policy. Why am I calling it that? Well, because if we think about in a sort of very broad and schematic sense about what we understand by public policy making, we might think about it as a relationship between choices that are made by those in power, authoritative government action by policymakers, resulting in a particular set of policy outputs, that is the programs, the policies that are created, and with a certain array of costs and benefits to particular constituencies that we think of the outcomes, right, of all this. And so in order to delink policy, as I'm calling it, you can break the link, or at least appear to break the link between either choices and outputs, or between outputs and outcomes, or both. And this is the way to try and provide some plausible deniability in court as to whether it truly is government state action that is producing a particular program with a particular set of results. So there are two different stages. Let me just go through these and I'll talk to you about how I propose to investigate this empirically. The first of these is this connection between policy choices that government actors are making and the intentions behind those, and then these policy outputs, these programs. And so it is, of course, important in many cases for policymakers to explicitly disclaim particular intentions. I mean, President Trump, for example, sought to do that with respect to his travel ban. The fact that he spoke openly about a Muslim ban was part of the reason that he drew First Amendment challenge, and that judges, lower court judges at least, were able to alleged discriminatory animus, religious and racial animus that underpinned that particular program. You can see in the cases of abortion, for instance, we have these programs being justified as women's health measures. We can see people who oppose amnesty and so on for concern, thinking in terms of concern for native-born workers, commitment to the rule of law as opposed to some sort of racial animus. You see this with respect to some of the electoral laws, voter identification laws and things, talking about integrity of elections as opposed to any kind of discriminatory animus that might underpin restrictive voting practices. So there's a question here about intent, and there's also a question here about the sort of delivery mechanisms that you use to actually create that policy, whether you're using, since constitutional rights, largely speaking, are secured against the government and not against private parties, it is extremely powerful for you in court to be able to allege that you have a private delivery mechanism, that this regulation is indirect, and thus you can deny that the state is actually involved in this particular program. And I see, when I spent a lot of time speaking to many legislators, advocates, policymakers across the US for my voucher work, I see people talking quite candidly about the sorts of policy designs that they are adopting, specifically with this downstream legal battles in mind. This is seen as the most palatable way of doing it. We're trying not to lose in this court situation. We want to do something that won't be challenged. We don't think you're funding the program directly, and thus that attenuated chain, where you have the state on the one hand and a private school on the other, that can help you to support it in court. But it's not just about policy design, it's also about your communications about that program. You have to be very careful about how you speak about these programs. You need to, first of all, take the emphasis off those particular outcomes, take the focus off the schools. Others see some hypocrisy here. It's thinking about voucher bills. Really it's a voucher bill. They call it a scholarship fund, but it's a duck to duck. But nevertheless, in court, these sorts of communication strategies can help you to try and make the case that this is not really going to have unconstitutional effects. You need to talk also about efforts to try to obscure your own intentions, any kind of unconstitutional intention. I mean, we see this in particular with respect to the white supremacists, the segregationists in the aftermath of Brown v. Board, who are creating these tuition grant voucher programs. And of course, also privatizing these various other institutions, these other public institutions in such a way as to seek to evade desegregation. But they're very, very bad about hiding their intentions in public. So they're saying things like, well, we're going to create these programs, it's to keep the schools segregated, despite the federal government, the brainwashers and the communists, and the courts are drawing attention to this disjuncture between the rhetoric and maybe some of the policy design elements in such a way as to expose that intention and to strike them down as unconstitutional. But it's not just at that first stage, of course. This is about denying a particular intention. It's about denying authoritative government action. But there's another way in which you can seek to delink policy, and that is at the second stage. So to think about, if you can argue in court that there is only limited effects, limited controversial effects, that it's targeted only at a very small population, that you can create a regulation that is officially neutral, which might have disparate impact effects, but which doesn't seem to have those broader consequences. For instance, we saw this, of course, famously with respect to the Trump travel ban. The Supreme Court holds that to be constitutional in Trump versus Hawaii on the basis, in part, that this policy covers just a mere 8% of the world's Muslims, and thus we can render that program constitutional. And so you can sort of deny that connection between some sort of neutrally written law or regulation and some sort of controversial consequence, whether that is closing gun ranges, or whether that's restricting the access to abortion, whether that is providing a benefit to a segregated or later a religious school. So I've tried to sort of schematize these, and you think about this, the array of options that are available to policymakers when they are considering how they might act in these various fields. So let's take abortion first. Of course, after Roe v. Wade, a direct ban upon abortion is a risky maneuver, because you risk obviously violating Roe v. Wade and being struck down as unconstitutional. But there are a variety of indirect and subtler ways in which you can seek to restrict access to abortion in ways that might be more constitutionally acceptable. So, for instance, you can try to nudge women to forego the procedure through sort of waiting periods and looking at ultrasounds and sort of requiring to go to the clinics twice and that sort of thing. After Planned Parenthood versus Casey in the 1992, where we have the substitution of a sort of undue burden standard in abortion law, that becomes a really important part of judges and justices' decision making in these cases. They're saying, well, do we have, is there an undue burden being presented? And if you're regulating these practices in a more indirect fashion, then you are less likely to fall afoul of that particular undue burden standard. But there are even more subtler ways in which you can try to restrict access to abortion, and that is through these targeted regulations of abortion providers, trap laws, known to their opponents as trap laws, where you are regulating, at least ostensibly in the interest of women's health, the providing for admission privileges for these clinics with hospitals, regulations related to room size or corridor width, and so on. Now, lest you think that I am concerned primarily with conservative approaches to policymaking, I'd like to also draw an analogy here with some of the approaches that have been made by liberals with respect to the politics of gun control. And of course, under the current, I mean, even back as far as 1934, where we have the National Firearms Act, and you have the efforts on the part of Congress to try to ensure that those legislative efforts to try and regulate guns would be acceptable as a usage of Congress's power under the Commerce Clause. You have the Attorney General at the time, Homer Cummings, explaining that gun control measure would be based on the tax power in anticipation of constitutional challenges. He's saying, if we made a statute, this is a quote, if we made a statute absolutely forbidding any human being to have a machine gun, you might say there is some constitutional question involved. But when you say we will tax the machine gun, you are easily within the law. As interlocutor says, in other words, it does not amount of prohibition, but allows of regulation. Cummings says that's the idea. We've studied that very carefully. So there are ways in which you might regulate guns, of course, more directly through a simple ban on particular possession within a jurisdiction. But of course, especially since 2008, and it's DC versus Heller, and of course, those maneuvers become riskier for policymakers who are seeking to restrict gun access. And so there are various indirect regulations that that legislators have adopted to try to nudge people in the direction of reducing access to these firearms, but also of regulating those providers as well, using nuisance and environmental laws to apply them to gun ranges and stores and shows, providing some burdensome administrative requirements that providers need to adhere to, in a way that, and what we know from on both the abortion case and in the case of gun control, that there are effects of these indirect regulations, and it is the case that the provision of these more burdensome regulations has the effect of reducing the availability of abortion, the availability of guns within a particular jurisdiction. So how does it work in court? It's about breaking the connection, or at least attempting to, appearing to break the connection between authoritative state action and these constitutionally suspect policies, and trying to sort of persuade justices and judges that the statute's motivation was emphatically not to prevent women from accessing abortion, to infringe Second Amendment rights, to disenfranchise certain voters, to support private religious or segregated education. John Paul Stevens, actually, when he was on the Seventh Circuit, in a gun rights, a gun control case, used a very interesting phrase, which is, he says that the use of a third party's legitimate discretion in denying a gun sale breaks the chain of constitutional causation. So there are various tactics that I think that policymakers have adopted, in many cases successfully, to try to enable to circumvent some of this these constitutional objections. If you can also characterize those laws as having a valid purpose with only incidental effects upon a protected right, then also you have the possibility of being able to protect them more easily in court. If you can allege the downstream burden of those particular policies is small, it's easily ameliorated, then you have a chance. There is no constitutional objection to a purely private hospital allowing refusing to allow their facilities to be used for abortion. There is if you charge a fee to federal firearm licensees for background checks, that is constitutional, because the courts have determined, because licensees are private entities and buyers are not affected by state action. But then on the second side, at this later stage, the outputs to outcomes, even quite a substantial burden can pass constitutional muster if you can allege that it is not eliminating a right to abortion or to gun possession. A New York court in 1979 held that these clinic regulations that interfere with obtaining an abortion are okay, they're constitutional, because women are still free to decide whether or not to terminate a particular pregnancy. Safe storage requirements for guns have been sort of held to be constitutional on the grounds that they burden only the manner in which someone exercises a constitutional right rather than the fundamental right itself. But the more obvious the effects, the harder it is for policymakers to plausibly deny them in court. Certainly you've had these particularly egregious examples where, for instance, Wisconsin Governor Scott Walker sort of, signed into law on a Friday a bill requiring hospital admitting privileges of all the abortion clinics in the state by the following Monday. Of course, even if it hadn't been a weekend, this process takes months and it's not at the discretion of the clinic. And so it was quite obviously an effort to close all those abortion clinics. Of course, that was the effect. And so that's on that basis, the courts are easily find that unconstitutional. You see these sorts of reasoning also in cases on gun rights, even when legislators have sought to use zoning laws, for example, to try and, as judges have said, redline gun stores out of existence. Judges have drawn that connection. There was a Massachusetts court that decided that the decision to place abortion clinics on the list of prohibited uses of industrial parks alongside junkyards, piggeries, trailer camps, and so on, and in quote, would be in substance the same had the regulation taken the more obviously grotesque form of zoning out of the town the private offices of any physicians who propose to perform lawful first trimester abortions there. There's the more obvious the effects, the harder it is for policymakers to plausibly deny them in court. But if they're able to target and to focus their policy on particular smaller populations, they might be more likely to be able to uphold it in court as constitutional. So I'm going to test. This is a statistical analysis that underpins this paper through two original databases on individual judges and justices' decisions in abortion cases and gun control cases, in order to identify how tolerant are judges and justices of these various different forms of regulation of these different practices. And I've got these original databases that I've collated over the course of the last, the modern period really, of abortion jurisprudence and of gun control jurisprudence over the course of many, many decades. And the dependent variable here is whether the judge or justice votes to uphold or to strike down that particular regulation. So any positive coefficient you see will represent variables that are associated with support for abortion restrictions or for gun control measures. And what we know, and what becomes abundantly clear through my own analysis of these two databases I've collated, is that the partisanship has an enormous role to play. And I think that we can certainly see that the partisanship of the judge or justice or their elected appointer, which of course is a very good proxy for judicial partisanship, is strongly statistically significantly related to their decision in these cases over the course of this period of time. But even controlling for that partisan affiliation, there is a role for policy design. So here are the effects for abortion regulations. You can see here I've got all these different categories of abortion regulation, and you can see here the difference of the probability that a particular policy will be upheld in comparison to a full ban on abortion. And what you can see is that for the most part, although not for every single category there, indirect regulations of abortion, things like informed consent laws, parental consent laws, Medicaid bans, a ban on using Medicaid funds to actually procure an abortion, and so on, record keeping rules about disposal, rules about building requirements, and so on. All of these sort of targeted regulation of abortion providers, those are much more likely to be upheld as constitutional than a direct ban on abortion would be. And you see the same dynamic with respect to the politics of gun control as well. I mean, you see that in comparison to direct bans upon the possession and use of guns in particular jurisdiction, you see that the indirect regulation of guns, whether that's zoning requirements, licensing, background check regimes, dealer requirements, those are statistically significantly more likely to be upheld as constitutional than a direct ban on guns would be. It's a story that I see, it is absolutely a story I see in conjunction with the material that I gathered on vouchers. And I just give you a little sense of what I found there. I mean, that when policymakers are determining how they're going to design their policies in such a way as to insulate them from challenge, they can choose various different means. They can't give the money directly to a private school because many of these schools are religious in orientation. Of course, that would be an establishment clause question, but also because they faced many legal obstacles at the state level, where there is constitutional language which requires that state legislatures should have a duty to provide for an adequate public education, open education, different language. And so they are vulnerable to sort of constitutional challenge. And so they don't give it direct to the school, but they can give it via the parent through this voucher program. But they can also do it direct in this even more attenuated, complex way through the tax code, through tax expenditures, by providing a tax benefit to particular organizations that are providing a benefit to the parent to spend on behalf of the child. So it's a very attenuated chain, and in that way they're able to hide what they're doing. And what you find in the judicial data is that if you look over the course of the last 70 years of voucher litigation, that the programs that most successfully hide the role of the state by using these tax expenditure delivery mechanisms, these privatized delivery mechanisms, they are more likely to pass in legislatures, they are less likely to be challenged as unconstitutional, and then they are less likely to be struck down if they are challenged. So there's a sort of triple whammy effect for that particular type of policy design. And you can see this also in the judicial data, that the likelihood of voting in favor of a particular voucher program is much greater when the judge or justice is facing one of these more complex, attenuated, indirect policy delivery mechanisms than when they're facing a more direct one. And this, as I say, is holding constant and controlling for partisanship. So there is a role for partisanship, but I would say that in addition to partisanship, there is also a role for policy design. And I think that's pretty significant. So I just like to give you some concluding observations about what I understand this project going, because this is forging a path with respect to this conceptual apparatus, but also trying to plug this in, of course, to some of the really live debates that we're having currently about the relationship between courts and policymakers. So I'd say that this is a very careful, and it's a very iterative, and it's a very strategic process. And it's one that has taken place over a number of years, over decades, where legislators have sought to rewrite their laws in a way that will render them constitutional. And you can see this happening over time. Certainly we saw it with respect to the voucher case, where they're going back to the drawing board again and again and again. And in my interviews, I sort of speak to policymakers and they say, we realize this wouldn't work. We're going to try it this way. You sometimes have multiple iterations of rewrites in order to try to create a program that will pass constitutional muster. And also very concerted efforts to try to be careful about how they communicate about these programs as well. But you see this in respect to abortion laws. You see this in respect to gun control as well. I mean, you see Arizona, for instance, they adopted a parental consent provision for their abortion law in 1989, and then it was enjoined by the court, and so they rewrote it. They enacted a fresh statute. Louisiana's been repeatedly rewriting its hospitalization requirements over the course of a number of years as they are struck down again and again by the courts. And so this is an iterative game. It's a repeated set of interactions between advocates, state legislators, governors, and the courts. Of course, what we are witnessing now in these very highly polarized times is very, very powerful battles over who is going to control the courts. I mentioned, of course, these rhetorical strategies and policy design strategies that policymakers can adopt in an attempt to keep to protect their programs. But of course, policymakers, as we all know, attempt to drag judges and justices towards their ideal points, their ideological ideal points, by means of appointment strategies. And we've seen Republicans have been relatively successful in that regard. And Maya Sen and Adam Bonaker have got a wonderful book out about the judicial tug of war, in which they are describing that precisely that dynamic between in which partisans on both sides are trying to use this appointment strategy in order to shape the courts and to produce a more favorable outcome. So until you are confident that you can tilt these decisions in your favor by means of these appointment strategies, I would say that these sort of delinking strategies can be very successful for you. I think as conservatives gain more of a toehold on the courts, especially on the courts of the federal Supreme Court, we're looking now, I think, at a very serious challenge to Roe v. Wade framework. It's the turn of the other side to sort of adopt these indirect approaches. So I think it's an approach that is adopted by people who are not confident of their reception on the courts. And I think it has wide application to a variety of different policy areas, whether we're thinking about the travel ban, whether we think about some of the messaging surrounding the citizenship question on the census, religious exemptions to anti-discrimination regulations, law and order policies, voter ID laws, and various other second-generation barriers to voting, and some of the justifications that are used that are evinced not only in public but also in court, particularly to try to support the constitutionality of those programs. And so I think that all of these battles are sharpened absolutely by polarization that we see today, but also I think that who actually takes on these strategies and the relative costs and benefits of those strategies are affected by the extent to which you feel that you have been able to tilt the legal marketplace in your favor, in alignment, as it were, with the political marketplace, in alignment with those priorities. So I'll leave it there, and I very much look forward to your contributions and questions and suggestions. This is a paper that is at a very much a draft stage, so I think it's coming at the right moment. And I'm delighted to hear more from you all. So thank you.
Thank you very much, Ursula. That was a very stimulating paper, and I'm sure everyone in the audience has a lot of questions. I think I will ask people simply to raise their hand virtually, and then I will I'm sure Ursula can field your questions. I think I will start off. I've got a few questions myself, and I think perhaps some of the first questions that I have are, I guess, about the scope of this phenomenon. So first, really, what are the conditions in which policymakers might pursue this delinking strategy? And you hinted at this towards the end, talking about the alignment of the electoral and the legal universes. And I just wonder, is it as simple as when policymaker, or when they can't simply appoint favorable judges? And second, does it only occur with certain morality policies, particularly contentious policies, culture war policies, or do we see it elsewhere? So I think that's my first question. And actually, if you'd like I don't know if you want to answer that one first, or if shall I shall I give
Happy
you
to
one
take
more
them one
about
by
the
one. I mean, or if
Okay,
whatever you
sure.
prefer, Nadia.
Sure, go ahead. With I guess answer that one, and I can ask more questions later.
Okay. Well, I mean, thanks so much. I mean, I think that's really great. I think these are questions that I'm asking myself here now about the scope and conditions of this argument. I think that there are very particular circumstances, I think, when these policies become especially attractive. I think that although I am scrupulous, or at least I'm trying to be as scrupulous as I can in this particular paper about the symmetry of it, that these are not simply conservatives, but these are strategies that both conservatives and liberals have found it politically expedient, legally expedient to pursue at various different points. But it might be that there are particular aspects of this delinking process that I think appeal more firmly to one side or the other in terms of their policy desiderata. So I think that probably if we are thinking about privatization and this sort of delegation phenomenon, although as many of the scholars of delegated governance and so on have described, this is something that has been pursued by both liberal and conservative administrations. It is primarily a conservative approach. I think that I need to think very carefully about how I'm going to pitch this as to whether this is something that I think of as an entirely symmetrical phenomenon. I don't want to, I think that might help to just get one sense of the sort of possible scope conditions about the circumstances in which it might be adopted. But I think that it happens under very specific circumstances, and it does happen at a time at which you are not assured of a secure legal cushion, for example, when you are not assured of a favorable response necessarily in the courts, but also in which you are able to make those arguments. And so I think that it's perhaps at that sort of midpoint that you need to feel that you will have a reception, that your argument might have sway. And of course, judges, I continue to argue, although they are clearly institutions that are driven by attitudinal considerations, partisan considerations, strategic considerations, they are susceptible to reason giving and to evidence and to ideas, and the diffusion of those ideas that you can see from the sort of political marketplace, as it were, from the sort of policy interchange into the legal realm. I think you can trace that out. You can see that in judicial opinions. And so there are situations in which I think some of these ideas, they gain power and they become something that judges and justices need to reckon with very seriously. And so under the circumstances in which you have those ideas that you can draw from, and you are assured of some reception, but you are not assured of a positive response because you haven't been able to fully pursue that appointment strategy, or at least it hasn't been fully worked out, and so you're not sure, there's uncertainty. There has to be some uncertainty there. Then that might be the time at which you pursue those. I mean, there's two different ways of thinking about this. I mean, one way, the way that a lot of the people who think about the submerged state and so on think about the puzzle that they identify is, why would you ever produce something that is so Byzantine, so sort of complex and indirect and so sort of coy about what the government is truly doing for us, and how could you possibly? Of course, that comes from a very particular perspective, which is the assumption is that the government ought to be given due credit for what it does, and so that's how they set it up, and that's how they sort of motivate the puzzle. But I mean, I suppose you could say that for some of these policymakers, and I mentioned, come back to the conservative side of things, that they are drawn to those sorts of that sort of policymaking. I don't want to give the impression that judges and justices are fooled by any of this. I mean, this is not, okay, this might, Rachel. Okay, so go for it, and I'd like to hear more.
Well, I mean, really, I'm very curious about what this phenomenon tells us about judicial decision making. So I would love to hear a version of this story from the judge's perspective, because I think you made a very, very convincing case that this strategy is very deliberate, and a lot of the quotes that you showed, demonstrated that this is a very conscious strategy, and as you said, judges aren't stupid. And I just wonder if, do they always take these framings at face value, or is there something else going on?
I think one thing that I grapple with is I don't seek to make any kind of determination about the sincerity or otherwise of the judges and justices who are making these determinations. I think that would be, I mean, that's a fool's errand. I mean, there is no, I don't think that that's something that is susceptible really to this sort of investigation. But I can observe the sorts of ideas that are identified and the sorts of considerations that the judges and justices evidently seem to be to foreground and to seem to be important. And so in that way, you can get some sort of insight into how judges and justices are seeking to determine these cases. I think that, I mean, the area where I think that it can be really powerful to draw in the strategic, I wouldn't say cynical, but the sort of that strategic approach to policy making, I think, is where you think, well, on the policymaker side, and to sort of try and identify some of the considerations that they were thinking about when they were identifying these programs and passing them and seeking to litigate them. But yes, I think that there's a whole lot of really brilliant literature on judges and justices and their decision making with respect to case space, and some of the attitudes that they might evince through their decision decision making. And so I would never, I mean, I think I can be agnostic, I think, about the relationship, the sort of legalistic model versus the attitudinal model versus the strategic institutional maintenance model. I mean, clearly judges and justices are influenced by all of these considerations, but they are constrained in terms of how they present that argument and how they interact with other branches and speak about and publicly justify. It is an institution of public justification. That is what it is. I mean, it's a rational, they deal in rationales in terms of the sort of language that they can use in order to justify it. And so I don't necessarily think that it gives us I need to be very careful here about making any kind of determination about what's going on inside those judges and justices' heads. But I think that it is very valuable, I think, in terms of to trace out the use of particular rationales and the way in which those things switch between these different arenas of contestation. So in the voucher case, I mean, the idea of child benefit theory is a really interesting one, because that's one that is used to justify the constitutionality of these programs. It's something that arises first in 1929 in a little known case in Louisiana. It gets picked up later by by other courts and starts to become this sort of major sort of kind of touchstone within that jurisprudence. But it's one that makes the leap back and forth to the political arena as well. And so policymakers are starting to use this language about child benefit to the child, not benefit to the school. You know, we're again delinking. You know, we're not saying that this is a benefit to a school; it's a benefit to an individual, private individual. And so what's fascinating is to see how that works out in practice. And you can the only thing we have to go on here are on the judicial side, of course, is to note their votes and to note their public justifications for action. But I think that does give us quite a substantial toehold into how they're thinking about these programs and how they're trying to reason it out.
Yeah, and I think, I mean, probably ultimately continuing this project would give insight into that judicial decision-making literature, because I think this doesn't fit into those standard models, you know, the ideological and attitudinal and so on. So I think you could take that in a different direction. I see Gareth has his hand up. Gareth, would you like to?
Has he managed to unmute himself?
Yes.
Yes, okay. I thought that was a really great paper, Ursula. Thank you very much. I thought it was very closely reasoned, very articulately and attractively presented, and very large in its implications. So it's a shame that I probably have rather an ignorant observation to make about it. I mean, like you, I spent a long time immersed in the politics of schooling and somehow got out the other end. But looking at judicial politics, I really became very, very cynical about judicial decision making. I mean, I really just developed the sense that judges just made it up as they went along. So I found your talk very heartening and sort of somewhat reassuring, that the very fact that policy actors and legislators often have to go to such kind of often quite contorted ends in order to persuade judges and justices of their point of view really, makes me think, it really made me think in a much less cynical way that actually judges and justices, although they are ideological, they actually do take the law and the Constitution seriously. Like I say, so thank you. I found that a really a heartening finding. If that is a finding you want me to take away from your paper. That's it.
Okay. Yes. So, well, thank you very much, Gareth, for that contribution. I think that, I mean, of course, I have had a few critical responses to this paper, and I think that it needs to, sort of this is all mulling around. But one of the responses that was offered, was I thought was very reasonable one, was just what are you really saying? I mean, this is you're simply saying that constitutional laws are upheld and that unconstitutional ones are struck down. But I think that, I mean, I suppose that the two responses that I would have to that are, first of all, that we need to do, I really want to focus in on the policymaker, the interaction element here, that this is not just about what judges and justices are determining in a vacuum, but they are borrowing various languages, and they are grasping onto rationales that are advanced by policymakers, by advocates in defense of these programs in a way that will help to justify that particular decision. It might be that they are doing so in an entirely cynical way, but the result that there is at least some role for policy design does give us some hope, perhaps. But if it's just a question of the legal, the legality of the policy determines whether or not it's struck down as unconstitutional or upheld as constitutional, well, that's not surprising at all. But I think that I make no determination about the Constitution. I mean, I think that that is a question for legal scholars entirely, about whether or not these things are truly constitutional or not, and whether this is indeed a true reading, whatever that is. And there is such a thing as this is a clear way of determining what is and what isn't constitutional. I think what we can observe, interestingly, is that when you have policymakers creating these programs in these fashions, with a view to thinking about how they're going to have them decide what court decisions might come up down the road, that tells us something quite interesting, actually, that is distinct from just simply the observation that constitutional laws are upheld and unconstitutional ones are struck down. But thank you very much for your extremely complimentary comments. I'm glad that I've given you some hope. Yes. Yeah.
I'm going to disagree with whoever it was that criticized the paper on those grounds, because I think, I mean, one thing that you do, and that's one of the most interesting things about the paper, the most intriguing things, is that you're really tracking the development of a change in policy discourse or legal discourse. And actually that's related to another question I have, which is whether or not you noticed a change in time, and whether or not this phenomenon increases in periods of polarization. So do we see this? I don't know if you looked for that in your analysis, but I know your data sets go back to what, 1932, or it goes back to the 34. So I don't know, have you seen this strategy increase in recent years, or in recent decades, or do we see it do we see it being used in the 30s as well?
So I think that overall, so there is an overall time trend. I certainly found this, certainly with respect to the voucher case, you see that over time that judges and justices are becoming much more sympathetic to voucher programs over time, and you see that the development of that supportive legal cushion, and I think that is we see some similar dynamics with respect to these other areas of jurisprudence as well, and I think that maybe gives us a sense, so and that's natural, you'd expect that to happen, right, that over time, as this supportive case law is built up, it enables, but it also constrains judges and justices who may be otherwise disposed to be sort of, to feel differently or to decide differently in these cases, to take up that rationale and to consider it very carefully, and perhaps it might, at the margin affect what they are, what they are deciding. And so, yes, there's the time dynamic. I think it's that these things, there's two things that go on, obviously stare decisis, right? That sort of the reliance on these previous decisions, but also I think the diffusion of some of these rationales, and that sort of very, policymakers again and again, trying again, working it out, thinking, okay, so what can we do that will enable us to try again and see how it goes in court. So I think that there's a time trend where people are sort of getting better at this. But the thing that I find interesting about the time thing, Nadia, is that it relates back to your first question about the scope conditions, because I think that there must be a tipping point at which you are so confident of that legal cushion that you are freer to experiment with more direct ways of getting at what you want to do. And sometimes, of course, as we've seen with Roe, we've seen blatant, direct defiance, open defiance of the constitutional of constitutional law and norms and current case law, right? Where we have bans upon abortion that were constructed, and their supporters are very candid. It's the opposite of this attenuating, delinking rhetoric and all that stuff, where they're saying they're candid. This is designed to be an arrow in the heart of Roe, and that's what we want to do. And so they're trying to draw the challenge. And I think that one thing I'd like to think about more is the circumstances under which, or the sort of political calculus that might underpin this sort of opposite sort of approach, where you're sort of saying, right, I'm going to defy, direct and defiant. I think we saw that, of course, something that I was thinking about a lot with respect to the Trump presidency, because of course that is a presidency that in many ways embodies that direct and defiant approach to constitutional law and norms. But I think that it's something that is more widespread. I think it tells us something much broader about the Republican Party in particular. So I think that there are probably circumstances under which it is expedient to take that other approach. It might be that you need to draw the challenge in order, if you're confident that you've tilted the legal marketplace in your favor.
Yeah, I was. I should say one of my first thoughts when the Texas law came out was not only that I thought it would be likely to multiply in other states, but also that the form of the law, this kind of circumventing of state responsibility. I just started wondering how quickly and in which other policy areas people would start to take that. So I guess, in a sense, that's sort of what this paper is about, is tracking that since the 1930s.
Yeah, I don't know whether there are others that you've been thinking about in terms of, sort of areas where this might briefly be applied. I think that I'm wary of concept creep. I think it needs, for it to be meaningful, I think it needs to have purchase, and I think that it needs to be able to, I think, still sort of working out the sort of boundaries of this concept. And I think that maybe I think that there are ways that we can systematize. I've shown some of those, and some of these ideas, direct and indirect, think about different forms of regulation, but it might be that they're different sorts of thing that I'm describing, that maybe it would be better to separate those things out in order to better identify the conditions under which these things might apply.
Yeah, because I suppose, you began the talk by talking about creative lawmaking, creative legislation and policymaking, and I think that's certainly the case with the Texas law. But now that I'm thinking about the actual structure of the Texas law, I'm not 100% convinced that it actually fits under the delinking, because I don't think the motives are in question, and I don't think the effects are in question. But it is certainly an example of creative policymaking, creative framing, so that when it gets to the Supreme Court, it gives the judges an opportunity to say, well, we're not exactly going against precedent. This is a different formulation. So I guess I think
I think maybe one of, oh, Gareth, do you have something on this? No, you still got your hand up, by the way. You've got a legacy hand right there.
Oh no, it's a new hand.
It's a new hand. Okay. Well, okay. So I'll just say on this. So I mean, I think it needs to be the question of animus and of intention. I think maybe that's playing the spoiler role here, and I'm wondering where this fits, because I think that there are so many questions right now, and it's not just conservatives, of course, that are on the back foot in some circumstances in relation to the question of whether a particular policy is motivated by religious or racial animus, but also liberals, actually. I mean, the ongoing discussion about Blaine amendments, no aid provisions, and that we've got a big case coming up. We've had several cases over the last couple of years, Espinoza versus Montana, some of the Trinity Lutheran cases, these cases where the Supreme Court has said that these amendments are which prohibit public aid to denominational institutions of all kinds, including religious schools, most famously, are motivated by anti-Catholic animus. And there's a lively empirical debate as to whether that is indeed the case. I'm on the fence there, but I would say that at least some of them were passed at a time when significantly before the sort of major wave of anti-Catholic antipathy. So anyway, there are different opinions about this, but certainly that's a live debate, and it's one that puts the liberals on the back foot, those who are seeking to restrict the uses to which these programs are being put. And so I want to talk about animus, because I think animus is very much part of this conversation about determining the constitutionality of a lot of these programs, whether it actually is motivated by this or that. Of course, but it's a different sort of, so you can hide your intentions. I think that's the sort of makes sense, but it's not about, when you're privatizing, when you're delegating, you're not actually necessarily hiding the role of the state, in the sense that it's not a secret necessarily. It might be difficult for ordinary folk to understand, and there's a whole brilliant literature on the political consequences of the fact that many people misunderstand the nature and purpose, and indeed the existence in some cases of these sorts of programs. But in court, it's not about that. It's not about hiding. Maybe the word I've used the word obscuring a lot in the paper. Maybe it shouldn't be that, but it's about indirectness, I think. And I think perhaps maybe taking words like subtle or obscure maybe give you the impression, or might give the reader the impression that this is about pulling the wool over someone's eyes, but it really isn't. I think it's about what intervenes, what organizations or institutions intervene between the particular between authoritative government action, and that's why I'm sort of melding into that sort of idea of intentional government. So actually, that's where the animus stuff, but maybe it's a bit of a stretch, and the policy program at issue and the output of that policy program. So yeah, I think it's still mushy, but it needs, this is really helpful.
Yeah, no, because in that case, then the Texas law fits perfectly, because even though everyone knows what's going on and what everyone's motives are, it's still out of the reach of the state by its structure. Gareth, do you want to jump in?
All right. So this is, it's not really reasonable to expect you to be able to answer this, Ursula. So but it's possible that actually that Nestor or Nigel or Nadia or other people whose names I can't see but are in the audience might have a thought on this. This model of judicial politics that you've been outlining, is it like utterly unique in global terms? Are there any other polities that have a form of judicial politics that even vaguely resembles this?
I think that's a really excellent question, one that I'm afraid I'm completely ill-equipped to answer, as you quite rightly identify. But I would say, I think that a lot of, certainly and it comes back to Nadia's question about the choice of the scope conditions in terms of the policy areas, in terms of the sort of the rights at issue. I think that it's very, very rooted in the American political development tradition. It's very much rooted in the American politics, which of course has always foregrounded the role of the courts, and those that many in the audience I'm sure know even better than I do, but just that peculiar role that courts play, and also the peculiar role with respect to the constitutional inheritance as well, that plays a really crucial sort of causal role in this particular discussion. So I think the dynamics though are the same. I think that the kind of some of the motivations, and I think some of the array of strategic options that face policymakers and legislators when they come to interact with one another, I think that is a place where it could potentially translate abroad. But I think that the substantive discussions and the substance of the specifics of the ideas, which I think are really important, actually, the rationales, the specifics of those ideas are quite, they are derived from that American political tradition. I think it's quite difficult for me to see how those would translate. I don't know what others around the room have. Whether, of course, we have a comparative conversation here. I don't know whether there are others who have different perspectives.
Well, I mean, I don't have an answer either, but I think one thing that your argument does bring out, what this entire phenomenon brings out, is just how deeply litigious America's political culture is, which is, I mean, something we already know, but it emphasizes that, and that these kinds of strategic decisions are going to, and complex strategies. That is an effect of having such a litigious political culture. But yeah, I'm not the person either to respond.
I'm not an expert on judicial politics, but I think there is something very peculiar about the relationship between policymakers, citizens, and the judiciary in the US. I mean, there is something in the nature of the interaction that is very unique, I think. I mean, from my point of view, in many countries, you're going to find these kind of interactions between policymakers, citizens, and the judiciary. But the way in which that interaction happens is in the US is very unique, I think. I guess it's very unique because of the nature of the political institutions in America, I guess. But I'm not an expert on this, so better to shut up.
I have another question that is really beyond the scope of your paper, Ursula. So you might not have a direct answer, but I just wonder. I'm always preoccupied with the unintended consequences of policies, and I think in particular because what you are tracing is are creatively structured policies. My guess would be that the danger of having unintended consequences would be relatively higher than in standard policy making. So I just wonder if as you were compiling your databases, if you came across any particular policies that you could now look back with hindsight and think, oh, that particular creative twist in the structure of the policy 20 years later or 30 years later had a very unintended, either desired or undesired consequence?
I think that's a really great question. I mean, I suppose it's a great question partly because the whole of this discussion is about the ability to try to deny a particular intention, to describe a particular set of policy effects as mere spillover, as externalities, and not as a central part of that intent, something that is explicitly intended in a particular policy. I mean, I think that so you're thinking about situations in which you might think about broader unintended consequences. I mean, I think that there are enormous number of this. I focus entirely here on the legal consequences of a particular set of political strategic maneuvers. Mm-hmm. But of course there are political consequences as well. I mean, Alexander Fattel Fernandez has done some brilliant work on policy feedback as a political weapon. I'm sure you're probably familiar with this idea that there are political consequences to some of these efforts. For instance, he's thinking here about efforts to sort of make it more challenging for unions to operate, which of course has enormous partisan consequences for the terms of political engagement because of the role of the unions within the Democratic Party. So he's thinking about ways in which you can try to demobilize your opponents and to bolster your cause through these sort of, sneaky ways. Or maybe not so sneaky, actually. Maybe you're quite open about exactly what you're doing. So I think that there's certainly a very rich and interesting literature on some of the political consequences of all of this. I mean, I think that I don't talk at all. This is a story about elites, and there are very important consequences, I think, in the public realm in terms of public attitudes, in terms of behaviors, in terms of attitudes towards democracy. And the general sense that there is a diminishment of trust when people are unable to follow the sort of links between authoritative government action and a particular set of programs and outputs and so on. Of course, that's not, I mean, there are many areas of policy. I mean, I don't think we can underestimate the extent of public ignorance, not only in the United States, but anywhere actually, of exactly the ins and outs of particular policy making. But I think that that problem is particularly acute for these areas where the policy is pursued in these indirect fashions. So yeah, there's a whole load of consequences in terms of, I don't know if this is getting to a question, there's consequences in terms of public attitudes, there's consequences in terms of political institutions, and in terms of the terms of political engagement. I think that I suppose that I think that I do still believe, although I certainly think that judges and justices are political actors, evidently they are political actors. They are acting in many ways along partisan and ideological lines, that there is still a role for ideas, and those ideas can take on a significance later on that can be quite consequential. In terms of what is available to the terms, those who are arguing a particular case or fighting a particular political battle. And so it can sort of structure the terms of engagement. I mean, I think that's a really vague answer. I can't give you a specific instance, but I think that there are, of course, all these spillovers in all of these other different areas of political life as well, beyond the legal realm. I certainly don't suggest otherwise. This is just one way into those questions.
Terrific. Does anyone from the audience have any more questions or thoughts or comments? Oh, Nestor?
Yeah, I have a question, but I don't know if it's a silly question, but you were comparing vouchers versus taxes, and your findings are kind of different when you focus on vouchers over taxes. I didn't understand completely well your argument there, so I wonder if you can elaborate a little bit more on that, because I guess there is something about the salience of the issue that could make a difference in terms of this argument that you're making.
Yeah, okay, glad you mentioned it. So salience, yes, but it's not playing the causal role that maybe you think it is. So there's a distinction that we want to make between a regular voucher program in which you're offering the fund to the parent through direct appropriation. You directly appropriate the money, you provide that money as part of a scholarship fund to the parent spends it on behalf of the child. That's a relatively simple way of thinking about it. But there are these more complex approaches in which, instead of directly appropriating the money, you are providing that benefit through tax expenditures. You're deducting the taxation that you would otherwise collect on donations to organizations known as scholarship tuition organizations, which are then providing the benefit to the parent to spend on behalf of the child at the school. So it's a different mode of funding that particular program. Now, there are those who hew to the idea of tax expenditure analysis, who say that those two sorts of funding are equivalent to one another. A direct appropriation is equivalent to a tax expenditure, because you're providing you are deducting tax, you are providing a particular benefit to a particular set of people. But then there are others that say that no, these are not equivalent, because actually this is private money. It is not actually governmental money, because it's simply it's money that would otherwise be collected in taxes, of course, but it's not equivalent to an appropriation. So they are not for legal purposes, but also perhaps for political purposes as well. So that's the distinction. But you mentioned salience. I think that absolutely has huge consequences politically, because those tax expenditures are far less salient than regular vouchers are. And one of the things that I find when I was talking to all my voucher, my interviewees, is that, you don't say the word voucher, for God's sake. This is really a dirty word. You don't say it. And so that there are all these various coy ways in which you can describe those programs. And also, if you use a tax expenditure, you can talk about tax credit scholarships, that sort of thing. It sounds better. But also it obscures, it's less salient to people, and it's not clear where that, in terms of the funding source. And so it's easier for both conservatives and for liberals, actually, to justify that in straitened financial times, and where you've got a very difficult, veto-prone system and all the rest of it. So, there is a political difference, but I think that it's not about the salience that is where it matters in court. It matters in court because it furnishes a rationale. If you are using these indirect mechanisms, it furnishes a rationale to judges and justices that can be used to support or oppose a particular, to justify a vote in favour or in opposition to a particular programme. So that's where I think it goes. It's not that judge, yeah. So that's, I think, the role that it's playing. But I hope that's laid those out clearly.
Ursula, I just had a thought, and it's not terribly well thought through, so I could, after I say it, I might decide that it was not a particularly helpful thought. But I'm just wondering if, thinking about the kinds of policies that are subject to this particular phenomenon, this delinking, I wonder if religious, how do I put this, policies that are on the religious secular divide are more, will be more subject to delinking. And I guess my logic is the following, which is that religious groups will need to reframe their policy goals in secular terms in order for it to succeed, for a policy to succeed. So, and I'm struck by the fact that 2 of your 3 examples, so if we include religious vouchers, school vouchers, are religious, basically, or sort of based in religious morality, whereas gun control is not, as kind of an outlier. But the other 2 are drawn strictly along religious lines, or maybe not strictly, but I wonder if that's a case that I haven't thought this completely through. So you might think otherwise, but I wonder if you'll see more of this delinking with regards to religious. I'm thinking a little bit also of John Rawls's conception of public reason, and where he says, people of different faiths can articulate their policy desires, but they have to do it using the public language that everybody shares, which is basically civic language. So
that's really interesting. That's really interesting. And that's a very intriguing thought. I suppose I think that they are religious in different ways, though. In the sense that I think that with respect to the voucher case, there's clearly an establishment obstacle. And so the question there about the proper relationship between church and state is ever present, and it is absolutely sort of really propels a lot of the action on this issue. I think that the abortion case, of course, as we all know, is only very recently something that has become something that divides, that has become a partisan issue, but also has become a very plugs into that sort of culture war distinction between the religiously orthodox and the progressives, because that it didn't used to be the case that the dividing lines were so stark about that. Andy Lewis has got some great work on this and about how abortion politics becomes part of these conversations. And so I think that, from the point of view of actors, yeah. So I guess I'm just trying to think, yeah, I mean, they're absolutely, they are religious, and they do invoke these religious questions, but I think they probably do so for slightly different reasons. But I think they I need to work this out. I mean, I think that there are a lot of things that there are other possible applications of this concept, maybe in other areas where religious exemptions and stuff and anti-discrimination legislation and stuff, that where it might be relevant as well. I need to think more about that, but I think it's a really intriguing thought. So thanks for that.
Great. Well, we could probably keep talking about this forever. But I think we should probably wrap up. I don't know if anybody from the audience has any further questions or comments or thoughts. I think Marietta posted a comment in the chat. Terrific. Yeah. So I'm just going to second Marietta's comment and say it really was an excellent presentation, very interesting, very well explained, very clear, and really quite intriguing. And I think it really helps us rethink a lot of these standard literatures, as you've said. I mean, both about policy making, but then also about judicial decision making. So thank you very much. And yeah. I'd just like to give you a round of applause.
Thank you so much for having me. I really appreciate the opportunity to present, and just delighted to be able to join the group. So thanks.
Terrific. And Nestor, this is our final one of this term, final seminar of this term. But I guess we'll be resuming this seminar series in January. I'm not sure what the first one.
Yes, in January we're going to have Diego Sanchez Ancochea from Oxford. He's going to be presenting his book about inequality.
Excellent.
So, yeah, I think it's going to be. Sorry, I don't remember the date exactly. I think it's the second half of January.
Brilliant, brilliant. Well, thanks everyone for coming, and I look forward to seeing people in person in the new year.
Goodbye, everyone. Have a nice evening.
Thank you.
Thank you. Bye.